Welcome to the Special Committee on Impeachment Inquiry this Thursday, June 1st at 9 o'clock. And our first order of business is adopting our committee procedures and rules. You should have received an updated draft, did you? Can't seem to find.
I didn't print it, but I did distribute it to people's email.
Oh, okay. All right. So if you could print out a copy from for who would like a printed copy of that one. We've got 4, including me. Some people are still in the paper world, including me.
I'll take one.
Make that 5.
For a clean version, if you print them, would you prefer to wait for a clean?
Oh, is the version that we have that was sent, does it show like highlighted the
I
change?
just highlighted them, did mark up for the one change.
Oh, okay. All right. So why don't we take a look? Can we get that online then to see that?
Yes.
Yeah, if you could, yeah, we'll welcome Jen Carvey to the witness chair.
Jen, right up on my screen if you want me to just share.
Great, that would be great. Thank you.
So there is one change that was made, which we'll take a look at.
Yes, so Jennifer Carvey, Legislative Counsel. So on page 2 of the document, this is the only change I have made since the previous version. In the middle of the page there around the member of the special committee may be designated to lead initial questioning of a witness, and after conclusion of the witness's initial testimony, other members of the special committee or special counsel to the committee may question the witness, subject to instruction from the chair. So that is the one change, just adding more special counsel.
And I'll explain the rationale for that is later, our second order of business is to vote on the contract for bringing on special counsel to help us with the Lavoie matter. And in discussions with him, he thought that there may be instances where he'll see a hole in the testimony and will want to ask a question at the end. And that made some sense to have that kind of discretion to allow special counsel to do so. Any questions on that particular change? All right, not seeing any. So the other thing I would like to actually address, we've, as everybody in the committee knows, we've received letters, input from a number of press people, organizations. We received a letter from the Vermont Press Association last week. And we answered that letter, a letter from Vice Chair McCarthy and myself. And then we have subsequently received a letter from Gravel and Shea that responded to our letter. And then we received a letter from the Vermont Association of Broadcasters, essentially saying we should follow what the Gravel and Shea letter said, and a letter from WCAX to the same effect. All of them urging us not to adopt rules and not to go into executive session. So, and I thought I would take a few minutes to add on to what we stated in our letter that is posted that responded to the initial letter from the Vermont Press Association. So just going to make a statement about that. But essentially, we've been relying on legislative counsel to give us input on whether it's appropriate to go into executive session. And we've also looked at precedents related to investigations of wrongdoing, as well as impeachment inquiries that have occurred in other states, as well as in Congress. So, but the special committee that we formed is conducting an investigation to determine whether to propose articles of impeachment. And the committee's work is not the equivalent of a civil trial or a criminal trial or pretrial hearings. It is its own animal, essentially, its own kind of investigation. But it is an investigation, and it is the equivalent, if we're going to look at criminal law, it is equivalent to a prosecutor or a grand jury determining whether to bring an indictment And such investigations are not done in public, not even as much public hearings as we have and are intending on having. So, but investigations are kept confidential for several good reasons and reasons that apply equally to this committee's work. Primarily, investigations are kept confidential to protect the rights and privacy of individuals, both of witnesses as well as the accused. And for witnesses, testifying about traumatic events can be emotionally challenging, especially for victims or witnesses who have experienced abuse or other forms of harm. Testifying in a public session with numerous spectators can be intimidating and can affect a person's ability to provide an accurate and honest account of events. Testifying in public session can have significant psychological impacts on individuals involved in sensitive cases, especially when their personal experiences are recorded and available online, subject to possible copying and rebroadcasting outside of their control. So allowing witnesses to testify in executive session addresses these concerns. Witnesses can share their experiences with the committee without fear of intimidation or retaliation. They can express themselves more freely and provide clearer and more reliable testimony. In addition, if we assure confidentiality, additional victims or witnesses may be more willing to come forward to offer testimony and evidence. The rights of the accused must also be considered. Preserving confidentiality safeguards their privacy and reputation until a thorough investigation is completed and wrongdoing is established. And if we ultimately do not recommend articles of impeachment, the confidential information we gather will not come out and damage the respondents. There are a couple other reasons for having executive session. And one is so we can obtain advice from our attorneys, from legislative counsel as well as special counsel in a confidential setting. If we don't receive our advice in a confidential setting, we are essentially letting the respondents understand what we're considering. And that really kind of undermines what we're trying to do. Also, we are allowed to review confidential documents. Documents that are confidential under law, under the public, are not allowed to be released under the Public Records Act, and we can review those in executive session. So these are all reasons why executive session is important for an investigation. So, but we can look at multiple, I mentioned we looked at precedents, and we can look at multiple precedents that support this committee going into executive session to conduct parts of its investigation. As we previously noted in our letter to the Vermont Press Association, other legislative committees with investigatory powers, such as the House Ethics Committee, the Sexual Harassment Prevention Panel, and the Discrimination Prevention Panel, have even more stringent confidentiality rules and procedures than those under consideration by the Special Committee for the Impeachment Inquiry. These panels conduct their investigations and hear testimony in non-public settings, and rarely are the witnesses or the information gathered during these investigations made public. I will also note that the Judicial Conduct Board is charged with investigating allegations of misconduct committed by judicial officers, and via the Supreme Court of Vermont rules, that board must maintain confidentiality of those investigations. Additionally, we have looked at procedures of the legislatures in Connecticut, South Dakota, and Illinois that have recently conducted impeachment investigations. And these states, as well as the U.S. Congress, have procedures requiring confidentiality and have conducted hearings in executive session during their investigations to determine whether to bring articles of impeachment. But most on point is our own impeachment precedent. In 1976, the Vermont House Judiciary Committee held closed-door sessions to hear testimony from witnesses in the investigation that led to articles of impeachment against Sheriff Mayo. So one last point, I'd like to address the Chapter 1, Article 6 of the Vermont Constitution, which was brought up in the letter from Ellen Shea. That provision provides that all power being originally inherent in and consequently derived from the people, therefore all officers of government, whether legislative or executive, are their trustees and servants, and at all time in a legal way accountable to them. So I certainly agree that we are indeed accountable to the people of Vermont. And the people of Vermont expect us to ensure that elected officials who breach the public trust, who act as state criminals, are held responsible. And to determine whether to hold them responsible through impeachment, the committee needs to weigh credible allegations that certain officials have acted as state criminals. And to do so, we must conduct a thorough and fair investigation. And to ensure a thorough and fair investigation, this committee will need to take testimony and deliberate in executive session. So I'm happy to take any additional comments or questions about that. But I did feel that we needed to address what we've heard from the various press agencies. Any input or questions on that aspect of the procedures and rules? Not seeing any. Any other questions about the procedures and rules? Representative McCarthy.
So, Mr. Chair, obviously you and I drafted and signed the letter in response to the Vermont Press Association, and I really appreciate the thought that Legislative Council put in and the feedback that we got around the precedents that you referenced. And I just wanted to underscore the difference between this investigatory phase and future phases, the work that this committee does, the report. We presume that if this did go to the House and then all the way to the Senate, that that there would be lots of opportunity for folks to examine the reasons we might propose to adopt articles and then to present evidence to the Senate. But that in order to find out the facts, we need to be able to offer people the opportunity to testify and present evidence in confidence and behind closed doors. And I think we all take really seriously how important it is to inform the public of our work, but we can't proceed with this work if everything that this committee does during the investigatory phase is in public session. And that balance is not one that we take lightly.
Any other input, discussion? Otherwise, I'll take a motion to approve version 2 of the procedures and rules for the Special Committee on Impeachment Inquiry. Karen moved. Is there a second? Second. And I think we just go strong on this. I think we have a clerk to do roll calls, but I think that's going to really be for any resolution that we're proposing out of here down the road for impeachment. So all those in favor of adopting the procedures and rules, please raise your hand. And that's unanimous. So we will work under those particular rules. I appreciate it. Thank you, everybody. We're almost still on schedule.
And Mr. Chair, just would it be worth reminding the committee and anybody who might be listening that we do have the power to amend these rules as we go forward if the committee decides that we need to.
Right. Yeah. And I guess one other thing I forgot to mention about those procedures and rules is I did mention these other precedents for impeachment inquiries, and having looked at their rules, their call for going into executive session or behind closed doors or confidentiality were just really broad. We actually have put in these rules specific rationales for why we would go into executive session. So I think we're trying to be as transparent as we can while we're still able to do the work that we need to do. So the next issue is looking at and approving a contract for special counsel. So over the past couple of weeks, this is, we've expeditiously looked to find somebody who can help us out in preparing for testimony in the matter related to the state's attorney, John Lavoie. And we've talked to a couple individuals, and we did have somebody who is willing and able and has the capacity and definitely has the background to help us out. And that's Attorney Rich Cassidy from South Burlington. And I sent out to everybody the contract, at least I intended to. I think I did last night. Tell me if I neglected to hit send. So that is the contract that we have. Rich has years of experience in lots of different areas of law. I think generally in Vermont, an attorney has to be a general practitioner, but I know that Rich has really focused a lot on employment discrimination law, and I really feel that he would be able to help us navigate that area of the law that we don't necessarily have the expertise within legislative council. We have expertise on drafting those laws, but as actually prosecuting employment discrimination cases, we don't have that kind of experience, but certainly Rich Cassidy does. So I would take any kind of questions. I don't think we need to walk through the contract. That would perhaps bog things down a little bit. But I can, go over what the scope of work is so folks understand why we're bringing him on board. And the scope of work can be found on starting in section 2. And essentially, it's providing advice in advisory capacity to this committee on the subject of workplace harassment, discrimination, or other inappropriate conduct as it relates to the conduct of the subject of this investigation, that being State's Attorney John Lavoie, including how workplace harassment, discrimination, and other inappropriate conduct impedes or hinders the ability of employees or an office as a whole in properly performing the functions and duties of the office. So his services will include testimony, written or verbal, regarding how an investigation of workplace harassment, discrimination, or other inappropriate conduct should be conducted, the effect of such investigations on workplace operations, assisting us in conducting the investigation of workplace harassment, discrimination, or other inappropriate conduct, including preparing members of the special committee for their questioning of witnesses and consulting on document requests, and then also providing some analysis of what constitutes either discrimination or hostile work environment or retaliation. So those are the things that we're bringing Rich on. And are there any questions with respect to this contract? Yeah. Representative Dolan, I have to remember that I'm trying to be more formal than this year committee.
Okay. So this isn't posted. Will this be posted once we vote on it?
Yes.
Or, okay.
Yes. Yes, it will. And this is a sole source contract, which puts we're able to have a sole source and not go out to bid if it's $10,000 or under, because we want to get moving on taking testimony on this. Going through the bidding process would have taken some time, and we were able to find somebody who would be willing to help us out with that cap. So.
I have a question.
Yes, Representative.
The money that we're using to pay this gentleman with, I know that our other attorneys are already on staff and it's not a special appropriation to get their services from Mr. Cassidy. Where's that money coming from?
So that is from, first of all, Appropriations Committee did look at this, not this specific, but looked at generally whether there were funds. And what is the, probably are familiar which
Yeah, Legislative Council might be able to help us out with this, but it's the Appropriations Committee found that we would be able to, for these smaller contracts, be able to use money that is in the existing legislative budget. So the legislative appropriation has money available that is somewhat flexible for, the use to fund legislative activities, like when we have to go to conferences or the speaker has to, sponsor somebody's, delegation somewhere. So those more flexible legislative funds can accommodate these smaller contracts. I think if we were going to engage somebody with higher dollar amounts, we might have to seek some approval. But for these kind of relatively small contracts, the Appropriations Committee felt that we would be able to do that within the confines of those flexible legislative funds.
And did I read it correctly that the upper limit here for this person is 10,000?
Correct.
Yeah, and that limit really comes from, and I believe Michael Grady could probably back us up if we have questions about this, but that comes from the limit on sort of sole source. So we did look at at least a couple of different candidates for this position. One who, for various reasons, was unable to take the role, and it seems like Mr. Cassidy was a really good fit based on his experience and the fact that he's available on this kind of short notice. So this is a specific instance where, with a relatively small dollar amount and the urgency that we have, that it seemed like it was prudent to move forward.
Thank you.
Any other questions?
Just one minor observation. This is super technical, but where Mr. Cassidy had his digital signature, the date seems a little errant.
Yeah, I think that I did see that. Call that a Scrivener's error, right?
Absolutely. I just wanted to point that out. I don't know if that's something worth having revised or not, but I just wanted to.
I don't think that's
Cite
it. You know what? I will just cross out the 2.
There we go.
There.
That's just an extra digit.
It's just an extra digit, yeah. It's not, yeah. So I take a motion to approve the contract, Vermont House of Representatives Special Committee on Impeachment Inquiry contract with Rich Cassidy Law PC for consulting services.
So moved.
Motion and a second, Representative Brannigan, and all those in favor of approving the contract, please raise your hand. And anybody opposed, and there it's unanimous. Great. I will sign this, and we will, Ms. Cassidy will be here this afternoon to sit in on the discussion related to the Paul Franklin Collins investigative report, and I will give him this at that time. All right, so we are like almost right on time. And I know that we're losing Representative Brannigan for a little bit at 9:30, and I know that Representative Burnett has a phone call he has to take at 9:30, but I think we can proceed nevertheless. Next on the agenda is in respect to the matter of the state's attorney, John Lavoie. We're going to have an overview of some of the state's attorney's policies, and Annie Noonan is joining us on Zoom to walk us through some documents that are posted and that we received. And I hope you're feeling up to this, Annie. I'm sorry to hear that you're a little under the weather, but thanks for being here.
Thank you very much, Mr. Chair. And I hope you can hear me. I do sound a bit like a bullfrog, and I apologize. I went over to urgent care yesterday. They tested me for strep, COVID, and pneumonia, and they said I'm okay. But this certainly doesn't feel good. But I'll try to endeavor not to grate your ears too much this morning.
Sound fine.
Thank you very much. So good morning, committee members. For the record, my name is Annie Noonan. I'm the Director of Labor Relations and Operations for the Department of State's Attorneys and Sheriffs. And I've been in that position since April of 2017. The position was specifically created by the legislature that year following the Supreme Court decision called In Re Election, in which the state's attorney's employees were determined to be county employees in part, and as such, the Department of Human Resources advised the department that they could not assist with labor relations functions. So the reason I raised that with you today is that there are certain things, as we walk through these documents, you will see that we create some of our own, although we are covered by the collective bargaining. We've engaged in 2 very successful contract negotiations with our staff in the 14 offices, and we have adopted by agreement many of the policies that the Department of Human Resources, the state of Vermont, the Agency of Administration have put forward. And I will try to walk you through that. Briefly, in terms of the department, we have, as you probably know, 14 offices, approximately 110 deputies, 28 victim advocates, 35 administrative support staff. I came to the department after having served 6 years as the Commissioner of Labor. 3 years before that, I was with the University of Connecticut in doing labor work down there, and 30 years with the Vermont State Employees Association. My last 16, I was the director of the SEA. This issue came to me late in February of this past year by an evening phone call with about a half a dozen employees at the Franklin County office. All levels of employees were involved in that call. There were deputy state's attorney, victim advocates, and administrative support staff. I wrote my notes up that Monday. That was a Friday evening. We talked for about an hour and a half. I wrote my notes up the next Monday. I reviewed employment history of State's Attorney Lavoie in the system, and I went and met with John Campbell, our executive director at the department. We agreed that an independent formal investigation by an experienced law firm with lawyers who practice in labor relations, employment discrimination, harassment cases, and have significant experience in investigations of this nature should be brought on, so that the department itself was asking for a review by experienced independent people. I talked to VSEA to ensure that they would make themselves available as quickly as possible to represent employees in any of the meetings that were being scheduled, and they were quite cooperative and agreed. We left the scheduling to attorneys Stackpole and Brines, Karen Stackpole, Chris Brines. At the time, the letters are pretty standard. Every employee received a letter saying there is going to be an investigation into allegations of workplace harassment, discrimination, bullying, and intimidation. We did not give anyone what I would call a pass. And sometimes within employment investigations, you may actually ask to meet with an employee who you have no indication that the employee has anything to do with this, because it may be that the cash box got carried out the back door and the person sits next to the back door, and maybe a camera showed you that, Joe Blow carried the cash box. In this situation, we did not know what employees were going to share. So no one got a letter saying you're just a witness. Everyone got a letter saying you will be investigated. We're conducting an investigation into office workplace harassment, hostile work environments. Everyone got the same letter. I was contacted, and there is a policy that our department also adopts. It's called employment-related investigations. It is a DHR policy. We do the same thing. We use that policy. Which says that employees must participate in employment-related investigations scheduled by the employer. You must answer truthfully, and you must make yourself available, and that you have a right to union representation if you're covered in the bargaining unit. S.A. Lavoie contacted me. He also received a letter. He contacted me. He asked me if he was covered by that policy. I told him very specifically, no, you are not. As an elected official, you are not covered by this policy. It covers exempts, appointed, and all other state employees, but it does not cover elected officials. He asked me if he should participate. I said I could not advise him on that. He asked me if he should get an attorney. I again said I could not advise on that. He voluntarily participated when he was contacted by Karen Stackpole and Chris Brine. They will be here later today to review the report with you. They can discuss their investigation, the process, and the results. When the report came out, it was shared with the state's attorney executive committee, who asked John Campbell to call John Lavoie and ask him to step down. He said no. There was then the next day an all state's attorney meeting. 12 of the state's attorneys participated. They agreed to have a letter written to ask him to step down. He again said no. As an elected official, there was no disciplinary action that the department could take in terms of John Lavoie. So our process was to ask the legislative body to consider impeachment. We have filed with the judiciary professional responsibility conduct complaint, and to the ethics commission. I want to point out to the committee, what I think is obvious to many of you, that State's Attorney Lavoie continues to be in the office. The employees who are essentially whistleblowers are also in the office. We've been working with BGS to find alternate space and have asked John Lavoie's attorney to discuss with him that he ask him to voluntarily work remotely. We have not heard back on that. The department is approving telework agreements by any employee who is requesting that, which basically allows them to work from home except when they need to be in court. We have been providing administrative leave. Many of the employees have been attending medical appointments with their doctors. We have a tremendous amount of employees who are now on high blood pressure medicine, antidepressants. This has been extremely, extremely stressful for them. I've also continued to update the head of risk management for the state of Vermont, the head of the Attorney General's Civil Division, and recently we had a meeting with Secretary of Administration, Kristen Klauser, and with the governor's legal counsel. The purpose of that is that the liability that this situation has created for the state of Vermont is huge. And I will leave it at that. Mr. Chairman, I think what you might want me to do is just to go through some of the documents. I won't read them to you. Oh, I think I lost my camera. There I did. There we go. Sorry about that. So most of in here, I think, are pretty self-explanatory. There's the letter to Speaker Jill Krowinski, citing the Vermont Constitution, saying upon credible information derived from a formal and independent professional investigation into allegations of misconduct, the department believes the threshold for impeachment, namely maladministration of the office, has been satisfied. So that was the letter to Speaker Krowinski. The next stuff in the next number of information sheets are regarding the request from the Press Association, which I'm not, obviously you're going to work with Ledge Counsel on that. Article 6 is pulled out separately for you in this packet because we, in fact, do have and mirror very closely the state of Vermont's non-discrimination policy. It basically is in our union contract. It protects employees from all forms of discrimination under all protected categories. The main difference here is that employees report those incidents to the Department of State's attorneys and not to the Department of Human Resources for the reasons I mentioned before, because they do not provide labor relations assistance to the department. It also notes that employees are not prohibited in any way. If they bring forward a complaint through this process, they do not waive any other rights that they have under state or federal law. So, for example, the State Human Rights Commission may receive complaints on this matter. The federal EEOC may receive complaints on this matter. Okay. The next group of documents are in here just to show you what we expect from our employees. There's a whole section here on performance evaluations, and I will only in every job description that we have in the department, which would be deputy state's attorneys, victim advocates, administrative assistants, administrative secretaries, and program service clerks. Every one of them have a separate performance evaluation that outlines their duties. But in each, if you look through this, on each, there is a section called core values that says whether, and you are rated on that by our department, by the manager, by the state's attorney. It talks about respectful to colleagues, partner agencies, crime victims, and members of the public. Helps to create and maintain effective working relationships, creating a positive, inclusive workplace, welcoming individuals from all backgrounds, and valuing diversity. Does not engage in gossip, bullying, incivility of coworkers or others with whom our staff interact. I won't continue to read, but you see that these are core values that we expect all of our employees to adhere to, and they are rated on these. And employees who receive negative ratings on those are then worked with and counseled, and it can lead to either charges of misconduct or unsatisfactory performance, depending upon what it is.
Before you go on, just a question. I have a question, and maybe some others do as well. How long is, I see that this policy, it says May 12th, 2022. But is that when this started, or has this been in place for longer than that?
So the policies in terms of what I feel are reflected in some of the state of Vermont policies and under the contract have been in play a long time. Employees under our department were required for many years to adhere to the state of Vermont policies. This was an update because what I was seeing, or what I wasn't seeing, were performance evaluations being done consistently across the board, reflecting an employee's job specifications and tasks and these core values. So this was guidance to all of the offices as to why did they have to do an evaluation. We first had the union contract in play for 2020, 2-year contract for 2020 to 22. And the new contract is from July 22 through June 30 of 24. So the union contract also adopted more stringently policies for ensuring that performance evaluations were done. And I think that that was an important piece. So this went out to remind people, you know, we're not seeing evaluations, and you need to be looking at evaluations for all staff.
So what, is there some guidelines that predate this that state's attorneys were looking at in evaluating their employees before May 12th, 2022?
They would have been using, prior to that, they would have been using the Department of Human Resources guidance and their direction, and they had very similar directions on how to do a performance evaluation. They actually have almost like a toolkit, and I think our state's attorneys were using that and were able to access that. This was, once we became our own bargaining unit, we thought that we would adjust the evaluation to be much more specific to each job title. And we could do that because we actually negotiated that in the contract.
I appreciate that. And if it's possible, if we could get what the predecessor to this guideline was.
Yes.
So that. Thank you.
Yep,
Any
absolutely.
other questions at this point? Representative Dolan.
Yes, thank you for providing this overview. I guess my question is with this, so this would be for staff, so this would not be for the elected official or state's attorney?
That is correct.
Is there an evaluation procedure for that individual or no?
There is no evaluation for that because of their status as an elected employee. It would not, I mean, John Campbell works for the state's attorneys, not the other way around. So, you know, the staff does. So we would not be evaluating them. I think the reason that this is somewhat instructive is that when you look at what a state's attorney is going to be asking their employees to adhere to as standards of performance, as core values, it seems to me the logical extension is you don't ask your employees to be respectful, civil, not engage in any type of harassment or bullying or gossiping, and then do it yourself.
My other question with this is, because you were talking about the current environment within the workplace and how folks are having a hard time and there's different accommodations that are being made. What's happening with evaluations right now?
Just in that specific office?
Yeah, well, yeah, I guess because it sounds like there's different accommodations, and I'm guessing evaluations impacts people's ability to move forward in their workplace. So is that part of the accommodations that are being looked at?
Right. We would not allow someone getting a telework accommodation or other type of an accommodation to adversely impact an evaluation. One of the things that the employees have very specifically asked is, since they've come forward, are they subject to being dismissed by State's Attorney LaVoy? And we have said, and the executive committee of the state's attorneys had said, is he would not be permitted to dismiss any employee based upon coming forward with this complaint. I think that by extension would be if we received an adverse performance evaluation, I would suspect that the department would not consider it and would not approve it.
Thank you.
So just to make clear, so you actually approved these performance evaluations.
So they have to be submitted up through the department. You will see that at the bottom of page 1, there is the supervisor's signature, and then there is the reviewer from EDO, Executive Director's Office, Labor Relations Unit. So that would basically be, we both have to sign. That would include the SA and myself have to sign evaluations before they are adopted and put into an employee's personnel file.
Okay, I'm not seeing where, I'm wondering if I'm looking at the right document, that maybe this is just the guidelines. I'm not seeing the actual performance.
Okay, well, I hope that was a packet. It may not be. If not, I will get you a copy.
Yeah, that'd be great.
Okay.
Right, thank you.
Okay, terrific. Thank you. The remaining policies were when we first started negotiating with VSEA for the contract, we had to agree upon what state policies we would adopt as part of this bargaining agreement. And I won't go through all of them very specifically, but you can see we agreed with VSEA we would adopt policy number 3.0 of the state of Vermont, which is equal employment opportunity. We have adopted the state of Vermont EEO and plan. We have adopted the sexual harassment policy with the exception of asking employees to report to the department, not to the Department of Human Resources for the reasons I've stated before. The prohibited conduct section of this is very important because it talks about the fact that a manager, supervisor, and employees shall not threaten or insinuate, either explicitly or implicitly, that an employee's submission to or rejection of sexual harassment will in any way affect the employee's employment, their evaluation, their wages, their advancement, their assigned duties, shifts, or any other condition of employment. You may hear later today, and you may have seen in the report that there was, in my view, and I believe in perhaps Attorney Stackpole and Brian's view, an employee who asked about, who was a temp, who asked about permanent employment after she had counseled S.A. Lavoie for some very bad language that morning towards another employee. And then later that day was asking about full-time employment and was told, no, not you. You should not expect it. To file a complaint again to the department. I mentioned to you that we have been keeping the appropriate entities in state government advised, particularly the head of the civil division of the HE, Laura Roundtree, risk management, Rebecca White. And as I said, we also met with Kristen Klauser and Jay Johnson because of the liability that this situation has created. Reasonable accommodation we have adopted. That has not yet come into play on this. So I will just say that it was adopted by the department. Discrimination complaints. I think this is an important policy because it talks about the contractual and legally that the state of Vermont is opposed to discrimination. We're contractually and legally bound to prohibit unlawful discrimination in the workplace on the basis of, and the whole list of protected categories.
Before you go on, I want to make sure that I'm following on a couple things. So I'm looking at the sexual harassment. This is actually the second document in this packet, September 13th, 2015. I just had a question on that one. As far as it talks about every manager and supervisor within the state of Vermont is responsible for providing a workplace free from sexual harassment. Any manager or supervisor, this is at the bottom of the page 1 of 5, any manager or supervisor who fails to treat sexual harassment complaints in a manner consistent with the terms of this policy may be subject to disciplinary action, up to and including dismissal. Of course, that's not the case of just that you can just dismiss a state's attorney who's been elected. But what are the expectations that the Department of State's Attorneys and Sheriffs have for state's attorneys in following these particular policies?
We fully expect the state's attorneys to follow these policies. We train in these policies at our annual training in June. They've been trained at least, I think, 4 or 5 times in the past few years on these, and we expect our state's attorneys to abide by the policies as we do our employees.
And this may, I don't think it's a rhetorical question, but that's one that needs to be asked. So what do you do if they're not following the policy?
Well, I think the first thing we would do is we would, depending upon the severity of the situation, I think John and myself would probably do a sit down with the state's attorney to ensure that we got them back into compliance. But if it was, as in this situation, severe enough and extensive enough, and that we would move forward with a formal complaint, which is what we've done.
Representative Dolan.
So you mentioned that the training takes place in June of each year.
Yes.
How does that work when somebody is elected and they start in January?
We have been able to have permission to keep this specific topic available in our I want to say our library, our training library, so to speak. So it is made available to people who start like on January, February as new essays. In this situation, it would be important to note that S.A. Lavoie had been with the department for, I believe, over 30 years. He was actually part of the bargaining unit, the union contract. These policies were embedded into the conversations with the union and the union contract, that we adopted these either unabridged or abridged in minor part, for example, with who do you complain to if you have these complaints. So until he took over as state's attorney, he was a deputy state's attorney covered by all of this, including this policy and all other policies that affect all employees.
Okay, and there's documentation of who has been trained or given the training materials. So is there a process for that?
There is. At our annual training, people sign in because they are getting CLE credits. So they have to sign in. We have to have a very specific number of hours of training in certain things. There are mandatory trainings each year. This is one: employee, attorney wellness, harassment, diversity, equity. That's another mandatory. I think there are 4 mandatories, and I'm just not pulling them up because I'm still a little foggy in my head. But this is the mandatory trainings that they must attend.
Thank you.
Okay, and if you could kind of point to where you are in the packet, I want to make sure I'm following.
Yes, thank you, Mr. Chair. I think at this point, let me just back up. I think what we want to do at this point is just go to an employment policy 5.6, which is employee conduct. This is sort of the catch-all, for state government, telling employees, what is expected of them. And I just call your attention to number 7. Employees shall not discriminate against, intimidate, nor harass any employee because of race, color, religion, creed, ancestry, sex, marital status, age, national origin, handicap, membership or non-membership in the VSEA, filing a complaint or grievance, or any other factor for which discrimination is prohibited by law. So employment policy 5.6 is sort of what most employees who are facing misconduct charges, this is in almost every letter, basically saying you have engaged in some form of misconduct. And that's a policy we have adopted. Due process under requirements called the Loudermill process. That's basically because the employees are public employees. They have property interest in their job. Loudermill says that if you are contemplating suspending or dismissing an employee, management must present to the employee what the allegations of misconduct or adverse performance are, and that the employee has the right to present evidence challenging that information, and also to include witnesses who can also support their challenge. So a Loudermill letter is what employees get when they're going to be suspended, or when the state is or the department is considering any type of suspension or disciplinary dismissal. There is also policy number 9.1 for immediate dismissal, and it basically talks about immediate dismissals for things like gross neglect of duty, gross misconduct, refusal to obey lawful and reasonable orders given by a supervisor, conviction of a felony, conduct which places in jeopardy the life or health of a coworker or a person under the employee's care. I will also point out that under Title 24, a deputy state's attorney can be dismissed at any time, and it's also embedded into the union contract that a state's attorney may let a deputy state's attorney go for any reason, and does not need to provide just cause review for that. It doesn't happen very often. It occasionally happens. I'll give you some examples. Sometimes we hire people who have recently graduated from law school. They take the bar 2-3 times. They cannot pass the bar. At that point, it becomes very burdensome on the office to continue an employee who is not able to be in court without being supervised by another attorney. We don't have that luxury. Our employees have so many cases that we don't have a luxury necessarily. Now, that doesn't mean there's no mentoring. There's certainly mentoring and supervision while the employee is attempting to be admitted to the bar and pass the bar exam. But once, that may be an example where a state's attorney says, thank you for your service, but this isn't working. It also may be that it could be for misconduct, and it could be for adverse performance. Someone who cannot meet deadlines with the court, misses filings. Those are all pretty serious problems when we're representing the state and we're representing victims. So there could be. It doesn't happen very often. We have we have good relationships, I believe, with our offices and our employees, but it is available. And gross misconduct is one of the things, or gross neglect of duty, for which an employee can be terminated. We've also adopted the state's workplace safety and security. I put that in there only insofar as the fact that an employee who feels threatened on the job by either a client, a defendant, or even a coworker has the right to file what they call an SSIR. If they feel that there's been a threat, a security incident, they can file to the Department of Buildings and General Services. They can also ask the Department of Human Resources and BGS to coordinate restraining orders. Domestic and sexual violence policy, we have adopted that. In general, what that really is looking for is for the employer to recognize that an employee who is suffering from any type of domestic and sexual violence may experience erratic attendance, performance, and it's intended to basically say to the department and all departments, be aware that you need to assist employees who are in this situation, and don't come down on them for that. Understand that they're being victimized and traumatized. Interestingly, though, the state acknowledges that victimization can lead to absences, late arrivals, early departures, or decreased productivity. And this can happen at the work site by a coworker, by a supervisor. It can be perpetrated at a work site on an employee, not by an outside force, but even inside. And that is headquarters, SAS headquarters. We have been granting employees telework requests. We have been letting them take leave without charge to sick leave. We've been covering them with administrative leave because we feel that, in essence, this situation very closely mirrors a true victimization situation that I think this policy would allow. There is also the Department of Human Resources employee whistleblower protection that cites, of course, the statute. I think most legislators are very aware of the work that you've done in whistleblower protections for state employees, for healthcare providers, nurses. We adopted the whistleblower protection. These employees, in my view, are whistleblowers. I think you'll hear that from the experts who will testify with you later today also. In here also is Title III of the State Employee Labor Relations Act. That's incorporated here because this is the labor act under which our employees bargain. So I think many of you who have been on government ops have been, over the years, seen much of Title III and the State Employee Act. Our employees are covered by the State Employee Labor Relations Act for purposes of their contract negotiations. And then finally, I believe it's final, I included for you an entire copy of the collective bargaining agreement between our department and the employees. This is the current agreement. And if you have questions on that, I'd be happy to answer. And then I believe the last document is the Vermont State Ethics Commission complaint form that will show you that the department has in fact filed to the Ethics Commission, because the Ethics Commission actually also expects employees to behave within the law, not violate policies such as the law and policies such as discrimination. I won't read that to you because I think you've probably done some work with the Ethics Commission and you're aware of it. And then finally, there is the oath of office that was signed by S.A. Lavoie in December of 2022. And that concludes the documents submitted by the department. And I will, Mr. Chairs, I will get you the documents that you have requested.
Yeah, I think just to back up, I'm not sure that I have the ethics related document that you mentioned.
Okay,
The other thing that I see on here is a citation to 1 VSA section 317C. And question, is that the basis for having redacted the investigatory report from Paul Franklin Collins? Was that
yes.
the rationale?
Yes,
Okay.
sir.
All right. All right, appreciate it. Any questions? And I'm sure we'll be hearing more from you as we keep going, and appreciate the overview of these documents. That's very helpful. So we're seeing no questions. We're going to take a 10-minute break, and then we will move on to Damian Leonard is going to give us an